Hi, Manny Fitzsimmons. I'm your Washington Realtors legal hotline lawyer, and today's video is another in our continuing series entitled Real Estate Fundamentals You Should Know. And today we're talking about Form 22K, the Utilities Addendum. Let's first talk about the law that gives Form 22K meaning. There is a law in Washington, a statute in Washington, which says that an escrow company can be obligated to collect from seller at the time of closing funds necessary to pay unpaid utility bills owing to a utility company that has the authority to lien seller's property. Why do we have that law? We have that law because prior to that law becoming effective, we would have buyers move into their property, call the water company to turn on their water, only to find out that there's a $637 bill still owing from the seller that now buyer has to pay before buyer can get water to their property. Is that fair under the purchase and sale agreement? No. Was seller obligated to pay that bill themselves? Yes. Does buyer have a choice in the matter at this point? No, because if buyer wants water, buyer has to pay seller's old bill. Could buyer then go and sue seller for $637? Sure. But the law says, escrow, you can circumvent that bad outcome if you contact a utility company prior to closing, verify if there are any lienable and unpaid utility bills from seller, and collect those funds from seller's proceeds at closing, pay the utility bill, so that when buyer goes to hook up their water, all they have to do is provide their contact information and they've got water, no outstanding bills to pay. That's the purpose of the law. The law becomes effective in a real estate transaction by the buyer's broker doing two things. First thing buyer's broker has to do is on the face of the Form 21, or the statewide purchase and sale agreement that buyer's broker is using, buyer has to mark the box in the sentence that asks whether or not the parties want the services of the escrow company to collect seller's unpaid utility bills. That box has to be marked yes, and then the boilerplate language on the form itself references buyer broker then to attach a Form 22K. Now we get to the Form 22K. Buyer brokers have historically engaged in very bad practices with respect to Form 22K. And the bad practices that brokers have historically engaged in are to leave is to leave the Form 22K largely blank. They have buyer and seller sign Form 22K, or maybe they will do some skeleton approach to writing in maybe just the name of certain utility companies and nothing else. Why have buyer brokers fallen into that very, very bad practice? Because probably many, many years ago, it was more difficult for a buyer broker to be able to identify which utility companies service seller's property. Before the internet, for example, buyer brokers may have just been left to guess which utility company service seller's property. And so there was language added at the bottom of 22K which says that if 22K is not fully completed, then either seller or listing broker can fill in the missing information after mutual acceptance. Because of that language, because of old practices, buyer brokers routinely now leave Form 22K largely blank. What does that mean? Here's what that really means in the terms of a transaction. It means that once we have mutual acceptance, seller and listing broker never go back and fill in that information. So when escrow gets the purchase and sale agreement, including Form 22K, Form 22K looks the same as it did when buyer broker finished with the form, meaning most of the information is not included. The statute I described in the beginning of the video is triggered only by the buyer and seller's provision of all of the information required by Form 22K relative to each individual utility company. So if, for example, the water company has lien rights and buyer broker only identifies the name of the water company but doesn't provide their address, doesn't provide all of the information required by Form 22K related to that water company, then escrow has no obligation to contact the utility company, the water company, to determine whether or not seller's bill was paid. So now buyer is in a doubly bad position. Not only will seller leave the bill unpaid that buyer is going to inherit, but buyer is going to be led to believe by the terms of the agreement that the escrow company is looking out for them, when in fact the escrow company has no statutory obligation to confirm the payment of that water bill. And so when buyer moves into the house, calls the utility company and says, turn on my water, they're going to say, pay us $637 first. Why? Because buyer's broker didn't fill in Form 22K. Ask yourself, buyer broker, 2 questions. Number 1, what is seller's or listing broker's incentive to fill in the information on Form 22K? They have no reason to fill it in. We already have mutual acceptance. Filling in that information gives the escrow company the opportunity to assess the seller for any unpaid utility bills. Now, maybe that seems like that's fair and that's what should happen, but I asked you, what's the incentive for listing broker and seller to fill in the blank spaces on Form 22K? They have no incentive. Second question I want you to ask yourself is, really, how hard is it for you to fill in that information? Many times the MLS will identify the utility companies, or most of the utility companies providing service to the property. If there are utility companies not identified in the MLS, do an internet search. Or better yet, tag your buyer with that responsibility. Buyer, while I'm preparing the purchase and sale agreement pursuant to your instructions, why don't you get online and get on the phone, call the utility companies that we think provide service to this property and verify. The utility company may not give you a lot of information, but every utility company will let you know if they service the address that you give them. And if they do, then all the information that you need to fill in the Form 22K is publicly available information. It all has to do with the contact information for the utility company. Again, no seller account numbers. Buyer brokers, your buyers are going to continue to get hit with seller's utility bills if you continue to not fully complete Form 22K prior to mutual acceptance. And when that happens, buyer's going to look to you for compensation for those unpaid utility bills. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.